had ceased.
Oh,
Right. I'll look into that. It's back on now.
It's back on now.
Yeah.
But just to put everybody's minds at rest in terms of the recording, obviously, Mr. Yarwood was providing his closing statement. That will be ID 49 in the inquiry document library. Mr. Shipley, if you could put it on the inquiry document library.
Yes.
And I'd just confirm that Mr. Yarwood, bar the occasional stumble, which is inevitable when you're reading out that much text, he stuck to the written text of his closing. So nobody has missed anything in content terms, despite the recording ending. Okay, thank you, Mr. Shipley, for checking that for me. Mr. Cosgrove, are you happy to make a start for the council?
yes. Thank you. I hope everyone should have received a copy. We sent one about 10 minutes ago, I think, to the. Yeah, I can see nods. I hope it was so, madam. I'll get going. And okay. Just to say, as is normal, we included most of our references in the footnotes. It's the way we've done it, to the CDs and so forth. We haven't repeated the contents to the 2 or 3 detailed sets of submissions on law and sequential testing, but we referred to them, and so we incorporate them by reference. Great, thank you. With that said, in terms of preliminary matters, as we set out in opening, the proposed development that has been considered at this inquiry began life as an application that was validated in November 2018. It has therefore had a long history. The principle of development on the site is established by virtue of policies in the Derbyshire Dales Local Plan 2017, which allocated the site for a similar scale of development to that proposed by the appellant. Development proposals on the site pursuant to such an allocation are subject to compliance with other elements of the plan. The proposal is a controversial one, and objections were voiced by local members, residents of the local community, and the World's Action Group, WAG, during the course of the inquiry. The issue of flood risk was consistently raised as a major concern, but there were other issues too that were canvassed at various stages of the inquiry. Madam, as we explained in opening, and we reiterate here, the position of the council as expressed during this inquiry does not seek in any way to suggest that local members and residents should not have their say on this important development that will affect their local community. Moreover, the council accepts that the concerns expressed during the course of the inquiry undoubtedly reflect genuine problems with the proposed development and a desire on the part of those voicing them to act in the best interests of the community. The council considers, however, that such matters can be addressed by suitably worded conditions. Then I turn just to the background briefly of the appeal. When the council's planning committee considered the application in March 2024, it refused it, as the committee had at that stage a number of concerns relating in particular to a perceived insufficiency of information in relation to flood risk, biodiversity, and the impact on landscape character and appearance. In other words, reasons 1 through to 3. Given what was before the committee at that time, when it made this determination, this was a reasonable course of action for the committee to take. Despite viability evidence indicating at the time of the application it would not be viable to provide affordable housing, the council also had concerns about a failure on the part of the application to properly consider and or secure a review mechanism to keep alive the possibility of critical affordable housing provision being enabled if and when the proposal was developed out over many years and if the economic backdrop had improved, which is essentially reason for refusal 4. When the appeal was made towards the end of 2024, the council, as it is required to do, reviewed the position it had taken in March 2024. A team of independent specialist consultants, experts in the fields of planning, biodiversity, viability, flooding, and landscape were instructed and reviewed the latest material, including the grounds of appeal, the statement of case, and further material that had been produced during the course of the appeal, and the latest national as well as development plan policy position as it stood at the end of 2024 and indeed into the start of 2025. As explained in our opening, that was not an exercise undertaken lightly, but rather with considerable care and with the intention of assisting this inquiry process and ensuring the position of the council adopted on appeal reflected full consideration of all the updated material. It is obviously critical that local planning authorities undertaking such a review on appeal act in a way that addresses the evidence that has been presented and explained at the appeal stage. To do otherwise would not assist the running of the planning system, nor would it fulfil the role of the council as a responsible planning authority. However unpopular the result position may have been in some quarters, the council and those advising sought to act in a way that accords with national and local planning policy and legislation, and by giving the detail of the appeal proposal that was before this inquiry. And I turn to our position on the appeal of the inquiry. In terms of reasons for refusal 1 to 3, as explained in the evidence from Mr. Gritstone on behalf of the council, in light of the review that I referred to above, the council resolved on the 23rd of January 2025 that the concerns it had set out in reason for refusal 1 to 3 could now be met with carefully worded planning conditions. Through the course of the inquiry, those carefully worded conditions were negotiated between the parties and subject to scrutiny by you, Madam, during the conditions roundtable session. The draft conditions now before you all meet with the approval of the council's relevant subject matter experts. The conditions in particular require the submission of the detailed drainage and flood risk design proposals to be subject to review and approval in due course. The council and the appellant experts agree that this process will allow a robust evaluation of the flood drainage design to provide necessary assurance in relation to such matters, and in particular to address the concerns expressed by many in relation to surface water flooding. WAG, of course, take a different view and have presented alternative evidence in relation to flooding matters. The council respects this difference of viewpoints and notes, of course, it will ultimately be for you to grapple with the evidence and make your own determination in relation, of course, to those matters. Apart from the issue of conditions relating to drainage and flood risk issues, Madam, you also raised the matter of sequential testing, both in advance of and during the inquiry. We produced submissions to address those sequential testing issues raised by you, and for your reference, that's at CD 13.2. I don't read them all out again. The appellant has then since carried out sequential testing, and we have sought to provide you with further assistance in our response to that testing and the inspector's questions that arose as a result of this, and that is at CD 13.8. Madam, you also heard evidence from the appellant and WAG in relation to sequential testing, and has the benefit, of course, of those parties' written submissions on the issue. We have nothing additional to add to our earlier 2 sets of submissions on that sequential issue. We accordingly invite you to consider all of the flood risk and drainage evidence presented by the 3 main parties and indeed members of the public in reaching your determination. So far as landscape and visual matters are concerned, the council considers that the draft conditions have addressed the remaining concerns. In relation to the details relating to the appearance of surface water attenuation features serving phases 2 to 4 and the link road crossing the valley feature, these can be delivered in a manner that would not result in significant adverse effects to the character and appearance of this part of Matlock. The council does not, however, agree with all the assessments in the submitted LVIA, as we have explained in the landscape statement of common ground. There would be some adverse effects initially in relation to aspects of the proposal, but these are not of themselves, in our view, of a nature to support a basis for refusal when viewed in context. Again, WAG take a different view in relation to this reason for refusal, and again, of course, Madam, as you know, you'll ultimately reach your own determination on that particular issue. As explained in the biodiversity statement of common ground, provided suitably worded conditions or obligations exist, the proposal will not result in a significant loss of biodiversity. Discussions have enabled the council to agree what it considers are suitably worded conditions to protect existing biodiversity assets on the site. Given all the agreed matters and considering all the latest evidence, the council did not resist the principle of permission in the appeal process in relation to this strategically important allocated site. I turn to reason for refusal 4. And I say from the outset that it is important to note that the council still considers that the appellant should agree to provide a review mechanism in a Section 106 agreement so as to secure the possibility of future affordable housing provision, as has been indicated in reason for refusal 4. We consider this, in fact, to be critical. Accordingly, our position in this appeal has been that provided a suitable review mechanism is included in the Section 106 agreement, and provided suitably worded planning conditions or obligations are imposed on any grant, we don't object to the grant of planning permission. Whilst the wording of the draft review mechanism has been agreed between the appellant and the council, the principle of its inclusion in the Section 106 agreement is still resisted by the appellant. The draft wording, as you know, is set out in Schedule 2, Part 4 of the 106 agreement. In accordance with Clause 11, this will not take effect if you determine the review mechanism falls within the scope of clauses 11.11 to 11.1.5. The council have set out in our detailed legal submissions, which you'll find at CD 12.1, why, in its view, such a mechanism is permissible in principle, and provided you with 8 key points about why such a mechanism is necessary in the present context to make the development acceptable. But we don't rehearse those arguments set out in the legal submissions here, but we do invite you to reflect on them as part of your consideration of this appeal. In summary, we consider that the mechanism proposed is A, necessary to make the development acceptable in planning terms, given the clear planning purpose of supporting the aims and requirements of the development plan, and specifically 1, maximising the delivering of affordable housing in accordance with HC4, enabling there to be a, quote, clear agreement of how policy compliance can be achieved over time in accordance with paragraph 009 of PPG, and 3, strengthening the council's ability to seek compliance with relevant policies over the lifetime of the project in accordance with the same paragraph of the PPG. And B, it is directly related to the development because the development is expected to make a contribution to affordable housing, given the policy references, and C, it's fairly and reasonably related and scale and kind to the development, because the proposed clause, which you will of course consider in due course, will be properly and carefully calibrated by reference to the possibility of the scheme viably supporting affordable housing provision in the future. We note that the appellant has not identified any legal authority prescribing the approach advocated by us. Instead, they have sought to rely on 3 appeal decisions, each concerning 51 or fewer apartments or flats, in which planning inspectors determined that review mechanisms were not necessary to make those developments acceptable. However, it is important to point out that each appeal decision deals with a discrete set of highly specific local policy and contextual factors. They must be treated with caution because they do not establish a principle that review mechanisms are not appropriate in appeals such as this, but instead in our submission are examples of inspectors deploying their planning judgment in relation to the specific policies and contextual factors in play in those particular appeals. In any event, it is noteworthy that in the Harrow appeal, that was for just 15 flats, the inspector explicitly noted in paragraph 37, and I quote, "Moreover, the appeal scheme consists of a single residential building with a single stair core. I am satisfied, therefore, that it would be built in a single phase, and therefore, based on the evidence provided, a review mechanism is not appropriate in this case." Similarly, in the Stockport appeal, which was a scheme for just 40 apartments for retirement living, the inspector observed in paragraph 37, and I quote, "Moreover, as the development would almost certainly be completed in a single phase with an estimated build time of 12 to 18 months, it is not the sort of large multi-phase scheme where stronger arguments for a review or clawback mechanism may otherwise exist." By clear contrast, this appeal is one such large multi-phase scheme in which those stronger arguments for a review mechanism do exist, as we've set out in our legal submissions. nothing in the appellant's legal submissions compel you to decline to find that as a matter of planning judgment, a review mechanism is necessary to make the development acceptable in planning terms. Instead, for all of the reasons we've set out in those submissions, it is entirely open to the inspector, to you, Madam, to conclude as a matter of judgment that a review mechanism is necessary, and we invite you to do just that. Then, by way of conclusion, as we've set out above, provided all the agreed conditions are imposed, the council has no remaining objections to the proposed development, subject to there being a review mechanism to secure a contribution to affordable housing in the future. For all the reasons we've set out and in the council's previous submissions, such review mechanism is necessary to make the development acceptable in those terms. And without one, the council considers the appeal would need to be dismissed. Madam, we now invite you to consider all the evidence you've heard from the three main parties and to reach your decision in due course. Thank you very much.
Thank you, Mr. Cosgrove. And just for Mr. Shipley's reference, that closing statement by the council is ID 50. And that should also go on the website alongside the Rule 6 parties. So we're now at just before 10:30, so we're running to the programme. We're expecting closing submissions by the appellant from 11 o'clock onwards, and if you could provide the closing statement to everybody by email by 10:45 so that can allow for printing, that would be very helpful, Mr. Lewis.
Certainly, will do.
Okay, so thank you very much, and we will, unless anybody has any procedural or housekeeping issues to raise, we'll adjourn now for half an hour. Okay,
Thank you.
so the inquiry is adjourned until 11 o'clock. Thank you. Good morning again, everybody. The time is 11 o'clock and the inquiry is resumed. So during the break, everybody should have received a copy of the closing statement by the appellant, which is ID 51. And the appellant's also provided a legal judgment, Mead Realisations, the High Court judgment in relation to Mead Realisations, which is ID 52. Okay. Over to you, Mr. Lewis, for the appellant's closing submissions, please.
Thank you, Madam. As this inquiry closes, it remains the case that the Council does not object to the appeal being allowed, subject to necessary planning conditions and obligations. The appellant and the Council have agreed on a draft list of conditions and also on a draft Section 106 agreement that all parties will have signed within days. The only matter that the appellant and the Council have not been able to agree upon is whether a mechanism to review the viability of affordable housing is necessary in the Section 106 agreement. Nevertheless, they have agreed to accept the inspector's decision on whether it is necessary, with the Section 1 agreement providing for the review mechanism within it to be disapplied should the inspector not consider it necessary. The Council's acceptance that the appeal should be allowed meant that it played necessarily a limited role at the inquiry. The Rule 6 party, the Wolves Action Group, maintained its objection to the appeal across a range of issues, relying on a single witness, Mr. Roger Yarwood, a chartered town planner, to present its case. The appellant is grateful to Mr. Yarwood for his efficient and courteous handling of the case on behalf of the Rule 6 party. It enabled the inquiry to progress in a civilised manner as the appellant's expert witnesses sought to allay concerns expressed by local people about its proposal for the site. The appellant is realistic that not everyone's minds will have been changed by the evidence they heard at the inquiry. Insofar as concerns remain, however, the appellant hopes that these closing submissions will provide additional reassurance that the proposal can be built safely, that it will reduce, not increase, the risk of surface water flooding in the area, and that it will be a sustainable addition to Matlock in full accordance with the allocation of the site for housing in the Council's local plan. The following main issues, as identified by you, Madam, remain between the appellant and WAG. First, the effect of the proposed development on flood risk. Second, the effect of the proposed development on biodiversity. Third, the effect of the proposed development on the character and appearance of the area. Fourth, the effect of the proposed development on highway and pedestrian safety. Fifth, whether the proposed development would make an appropriate contribution towards affordable housing need. And sixth, whether the proposed development would make appropriate contributions towards community and infrastructure needs. I'll deal with each of those issues in turn. First, the effect of the proposed development on flood risk. The appellant and the Council agree that the concerns previously expressed by the Council in its first reason for refusal about needing more detail about the flood risk management measures proposed on site can be resolved by appropriately worded planning conditions. The appellant and the Council are both satisfied that the proposal can be delivered without an acceptable risk to public safety and would not result in flood risk on site or increased flood risk elsewhere. WAG was not willing to join this consensus and raised three main points in relation to this issue. First, the absence of a preliminary risk assessment in relation to the proposed attenuation ponds prior to the inspector's determination of the appeal, giving rise, they say, to concern about their effectiveness, safety and stability. Second, a claimed, and I quote, material change to the land drainage arrangements that were originally proposed in the planning application. And third, the claimed absence of a sequential test, considering whether there are other reasonably available sites for the proposal that are at lower risk of flooding. First, the effectiveness, safety and stability of the attenuation ponds. WAG's main contention under this heading was that it is unacceptable that the appellant is not seeking detailed planning permission now for the surface water attenuation measures proposed in the outline part of the application, because the decision maker must, it says, have certainty now that the development can be delivered in a way that will avoid unacceptable flood risk and store surface water safely. Mr. Yarwood clarified in cross-examination that he was not suggesting that there must be complete certainty now about the exact design of the surface water attenuation measures. What is required, he says, is certainty about whether it can be done safely. To this end, Mr. Yarwood was taken in cross-examination to several documents that he had not mentioned in his written evidence. First, Mr. Yarwood was taken to the document at Appendix 5 to the appellant's statement of case. That's summary of actions taken to address LLFA residual concerns. I'll call it the TT Actions document. Section 1 of the TT Actions document explains that the following matters had, by the time the document was prepared, been the subject of further discussions between the respective drainage experts of the appellant and the lead local flood authority, or the LLFA. First, the risk of seepage from the attenuation ponds. Second, the adequacy of the capacity of the attenuation ponds. And third, the stability of the attenuation ponds in engineering terms. As regards the risk of seepage, matter 1, section 2 of the TT Actions document explained as follows. A meeting was held with the LLFA on the 8th of August to discuss the above, that is the risk of seepage, and it was subsequently agreed that the basins would be lined to mitigate any seepage concerns. Although this is usually something that would be dealt with at detailed design, it was agreed with the LLFA that the pond within both phases of this development site would be lined, and a typical detail could be provided at this stage. Lining of the ponds will have the added benefit of providing greater stability to the basin side slopes. There are 3 widely accepted methods of lining the pond, either through puddled clay, geosynthetic, or geomembrane pond liners. Details for these are available in the Syria SUDS manual. The advantages of each would be considered at detailed design stage in order to arrive at a site-specific optimal solution. However, typical details were sent to the LLFA following the meeting as they requested. Correspondence with the LLFA and the details supplied are contained within Appendix B, end quote. Mr. Yarwood was taken in cross-examination to Appendix B of the TT Actions document as referenced in paragraph 2.4 that I've just cited. Appendix B is titled Pond Lining Details and contains an extract from the Construction Industry Research and Information Association SUDS Manual of 2015. This extract confirms, and I quote, that pond liners can be formed from a range of different materials and provides illustrations of typical geosynthetic, geomembrane and clay liners. Mr. Yarwood accepted in cross-examination that he had no basis to challenge the reliability of the information in this extract. There is no reason to think that it will not be possible to line the attenuation basins on the site to prevent seepage. Turning to the adequacy of the capacity of the attenuation bonds, matter 2, section 3 of the TT Actions document stated as follows, and I quote, "Under common law and riparian ownership rights and responsibilities, there is no responsibility on the landowner to attenuate flows from either upstream surface water flows or watercourses that run through their land. Despite this, efforts have been made to incorporate as much mitigation as possible for the existing flooding issues in the vicinity of the site and demonstrate the significant betterment to flood risks that can practicably be achieved within the constraints of the site." During the meeting with the LLFA in August of 2024, the LLFA acknowledged that there was no responsibility for the developer to attenuate these flows. However, they would like to see the attenuation ponds remain in the proposals due to the significant betterment they will provide to flood risk in the vicinity of the site and the surrounding area. Tetra Tech have carried out a high-level hydraulic model using 2-flow, with a more accurate assessment of the base flow over the critical storm duration rather than the 50 litre per second peak figure originally adopted in the calculations. This model provides a comparison of the pre- and post-development flood levels. The model demonstrates the significant betterment the scheme will provide, and the LLFA stated that this should give them greater confidence in the performance of the attenuation. The hydraulic model report was issued to the LLFA for review and is contained in Appendix C, end quote. Mr. Yarwood was also taken in cross-examination to Appendix C of the CT Actions document, as referenced in the last sentence of the paragraph that I've just cited, and that's titled the 2-Flow Hydraulic Modelling Report. Section 5.6 of that report is headed Result Comparison. Paragraph 561 within that section cross-refers to an appendix to that report, also labelled coincidentally Appendix C, which, and I quote, shows the surface water depth and extent difference between the baseline and development scenario hydraulic model results for all events simulated. This other Appendix C, titled Depth Difference Model Results, contains modelling outputs in the form of 3 maps. Map 7 shows the difference in the depth and extent of surface water in a flood event with 3.3% annual exceedance probability, or AEP. In other words, a 1 in 30 year flood event, comparing the baseline and development scenarios. Map 8 shows the same information in relation to a flood event with 1% AEP, or a 1 in 100 year flood event. And Map 9 shows the same information in relation to a flood event with 1% AEP, but with an additional allowance for climate change. The legend to these maps defines any light blue area on the maps as an area that, and I quote, was wet, now dry. The areas coloured green, both within the site and beyond it, are areas where a decrease in the depth of surface water is modelled in the development scenario when comparing it with the baseline. The darker the green, the greater the decrease. The areas coloured orange to red, with the red areas mainly corresponding to the proposed locations of attenuation basins within the site, are areas where an increase in the depth of surface water is modelled in the development scenario. The darker the orange or red, the greater the increase. In its Appendix C, two-flow hydraulic modelling report, Tetra Tech summarised the main points to take away from these maps as follows, and I quote, "Comparing the baseline and development scenario model results for all modelled events indicates that there is a decrease in surface water depths in the lower catchment to the south of the development site. Where there are minor increases in depth to the southwest of the development site, this is likely as a result of the on-site drainage network and infiltration processes across the catchment not being represented in the model, and the model overestimating the volume of surface water flow in this area." Mr. Yarwood confirmed in cross-examination that he had not provided any evidence or other commentary in response to this technical modelling evidence by Tetra Tech. He fairly accepted, therefore, that he could not challenge the conclusions that Tetra Tech had drawn from its modelling evidence, as I've just summarised. The appellant submits that the inquiry can share the confidence of the LLFA in the performance of the proposed attenuation ponds and the significant betterment they will provide based on this unchallenged modelling evidence. The stability of the attenuation ponds in engineering terms, matter 3, was the third and final aspect of land drainage that was the subject of further discussions between the respective drainage experts of the appellant and the LLFA. Section 4 of the TT Actions document summarised these discussions as follows, and I quote, "The LLFA agree that further work is required and a risk assessment would need to be carried out concerning the potential failure of the ponds. They are mindful that this should take place at the reserved matters discharge of condition stages as set out in their review of the JBA report. Notwithstanding this, Tetra Tech confirmed that a high-level slope stability analysis has been carried out by their geotechnical team to assess the risk of collapse. This analysis confirms that the safety factors against collapse of the ponds appear to be sufficient at this stage without the need for any special measures to be implemented. This can be revisited at the detailed design stage once the ponds are designed in detail." The LLFA stated that this should be sufficient at this stage and requested a copy of the report for review, which is contained within Appendix D. Further risk assessment is still required, including an assessment of the risk of blockages in the surface water network. Tetra Tech confirmed that the intention would be to look at this at later stages, as would normally be done for any other development with attenuation, seeing as this is not a risk that is specific to this scheme. End quote. Mr. Yarwood was taken in cross-examination to Appendix D of the TT Actions document, as I've just referenced, titled the Geotechnical Slope Stability Analysis Report, prepared by the Geotechnical and Engineering Consultancy COFI on the 7th of August of last year. Mr. Yarwood did not appear to have read this report in full before the inquiry. In section 1.1 of the report, Coffey explained that the purpose of the report was, and I quote, "to undertake a high-level assessment of the slope stability of the proposed attenuation ponds. Having identified ground and groundwater conditions at the site, the Coffey report explained that the initial assessment of slope stability had been undertaken using the software program Slide 2, and that, I quote, a global factor of safety of 1.3 is considered to represent acceptable stability, end quote. A structure with a global factor of safety of 1.3 is a structure that is designed to withstand 1.3 times its expected load or stress before it fails. The report then explained that, and I quote, the deepest proposed cutting and highest proposed embankment have been selected for initial assessment of slope stability, end quote, specifically the cutting on the northeast bank of Pond 1 and the embankment on the north bank of Pond 3. The result of the analysis was, and I quote, that the cross sections considered have a minimum global factor of safety of greater than 1.3, end quote, if standard assumptions about the construction of the ponds are made. Specifically, Table 3 in the report identified that the factors of safety for the deepest cutting, Pond 1, and the highest embankment, Pond 3, ranged between 1.39 and 4.22, depending on whether the ponds were drained or undrained, with the presence of water in suitably lined ponds having a stabilizing effect on the side slopes. This initial assessment enabled Coffey to conclude in his report that, and I quote, subject to detailed design, the proposed attenuation ponds have factors of safety against slope stability that are likely to be acceptable. The report ended with a series of recommendations on the matters that should be considered further when the attenuation ponds are designed in detail. Accordingly, the inquiry has expert evidence from a specialist geotechnical engineering consultancy that concludes that when the attenuation ponds proposed on the site are designed in detail, it will not only be possible but likely that they will have factors of safety that exceed the minimum required. It is also important to understand that as the attenuation ponds fill with water, they will, in fact, become even more stable. Once more, Mr. Yarwood fairly accepted in cross-examination that he was not in a position to challenge any of this expert technical evidence and did not, in fact, do so. Mr. Yarwood did, however, rely on an email that a civil engineer retained by the LLFA to provide ad hoc advice on reservoirs sent the LLFA on the 31st of July of 2023 in response to a request for advice on the attenuation ponds proposed on the site. This email was provided as Appendix 3 to WAG's updated statement of case. In this email, the civil engineer provides notes under two headings: hydrology and inflows and breach potential and consequence downstream. These notes included the following. On hydrology and inflows, we note that there are significant numbers of springs in the area, and determining the inflows from the springs is not easily evaluated accurately. From previous experience on other sites, we have seen springs fill up ponds with water, thereby reducing the storage capacity of the ponds right from the start. The contribution of groundwater flows should be assessed robustly to ensure this is not a risk. It would be advisable, where practicable, that natural flows routed through the ponds are limited to that which has been designed to pass the control structures, with all excess flows diverted away via a safer route. On breach potential and consequence downstream, holding water at this elevated level will increase potential consequence downstream. This is not helped by the fact that the most upstream ponds are also the largest. Whilst the area isn't necessarily steep local to the development, the gradients downstream are understood to be quite steep. We would suggest that the developer needs to include a risk assessment for hazard and consequence to assess the change following construction of those ponds, in particular considering cascade failure. I would expect this to include a breach evaluation of inundation area, flow depths, and flow velocities. An assessment of the impact on critical infrastructure, property, and life can be undertaken to enable a thorough risk assessment to be completed. In essence, this email in July 2023 was seeking to raise awareness about two matters that have since been covered in detail in the TT Actions document produced in August 2024, namely the adequacy of the capacity of the attenuation bonds and the stability of the attenuation bonds in engineering terms. The depth difference model results and the geotechnical slope stability analysis report were both produced in August 2024, thereby postdating the advice given by the civil engineer to the LLFA by email on the 31st of July 2023. Insofar as the civil engineer was advising the LLFA to seek more information and assessment from the appellant in relation to the two issues of the capacity and stability of the proposed attenuation ponds, this has since been provided. Unfortunately, WAG overlooked this further information and assessment in its written evidence to the inquiry. It offered no serious challenge to this further information and assessment in its oral evidence either, opting instead simply to defer to the notes made by a civil engineer in July 2023 that have since been answered and superseded. As the inquiry closes, nothing of substance remains in WAG's contention that it will not be possible to design and deliver safe, stable and adequately sized attenuation basins on the site as proposed. On land drainage arrangements, the second main point raised by WAG in relation to flood risk and drainage was to contend that there has been a significant change, it said, to the drainage arrangements that were originally proposed in the planning application. Specifically, WAG suggested that instead of using the existing outfall behind 5 Bentley Close to discharge surface water from the Phase 1 land of the scheme, as originally proposed, the appellant now proposes, it said, to avoid that outfall by, and I quote, providing 80 metres of culvert pipe to connect into the existing 300mm wall spring network pipe at an undetermined location on Gritstone Road, with flows now regulated at 33 litres per second. As the appellant's drainage expert, Mr. Ian Hilton, explained in the document at Appendix 1 to Mr. John Dickinson's rebuttal proof on behalf of the appellant, Drainage and Flood Risk Supplementary Technical Note on Rule 6 Party Proof of Evidence, WAG has misunderstood the position. In summary, the appellant's agreement with Severn Trent Water is to provide connection points to discharge water at a rate of 20 litres per second from the Phase 1 land and 45 litres per second from the Phase 2 land. This has not changed. WAG appears to have sourced the references to 80 metres of pipe and a discharge rate of 33 litres per second from the description of the existing drainage pipework included in hydraulic modelling provided in Appendix 5 to the appellant's statement of case. The 80 metres of pipe is the existing culvert beneath Bentley Close, which connects to the downstream sewer network and has a theoretical capacity of 33 litres per second. This existing discharge point and rate would be maintained with the proposed development in place. To be clear, no new 80 metres of culvert pipe is proposed in relation to Phase 1 of the scheme. The appellant's hydraulic model is predicated on there being 2 culverts downstream of the lower attenuation pond on the Phase 1 land, named in the model as Phase 1/3CU and Phase 1/out-C. Phase 1/3CU is the pipe from the downstream pond, and Phase 1/out-C is the existing 80-metre culvert at the boundary of the Phase 1 land running under Bentley Close. Having considered this further explanation from the appellant, Mr. Yarwood appeared to accept in cross-examination that it was no longer WAG's contention that there had been a material change to the land drainage arrangements since the planning application was made. This aspect of WAG's case was resolved. Sequential test for flood risk. The appellant maintains that there is a legitimate argument as to whether national planning policy in the NPPF and PPG required a sequential test for flood risk to be undertaken in relation to its planning application. The appellant's submissions as to why a sequential test does not need to be reapplied in the present case, given that a sequential test for flood risk was undertaken at the plan-making stage, were fully set out in the document Appellant's Response to Inspectors' Questions about Sequential Test, dated the 7th of March of this year. However, the appellant also acknowledged in those submissions that national planning policy is perhaps not as clear as it could be on this issue, and that the inspector could be assisted by further explicit consideration of whether the new areas of predominantly low surface water flood risk shown on the Environment Agency's flood map for surface water would have affected the outcome of the sequential test undertaken by the Council for the local plan. To assist the inquiry, therefore, the appellant commissioned Marans, a planning consultancy with extensive experience of sequential testing for flood risk, to undertake an up-to-date sequential test to consider whether there is another reasonably available site or sites that would be appropriate for the proposal in an area at lower risk of flooding. This up-to-date assessment was prepared on the basis that a reasonable area of search for other available sites should include the 3 first-tier market towns of Matlock, Ashbourne and Wirksworth. The assessment identified 5 potential development sites within the reasonable area of search, including the site, that could potentially accommodate the proposal and which should therefore be subject to sequential testing. In summary, having taken account of all sources of flooding in the sequential test, including surface water flooding, the assessment concluded that the site was sequentially preferable to the other 4 sites in terms of overall flood risk. WAG challenged Maran's sequential assessment principally on the basis that it did not agree with Maran's decision to identify the 3 first-tier market towns as the reasonable area of search. However, Maran's decision was consistent with the PPG on flood risk and coastal change, which has a section titled The Sequential Approach to the Location of Development. The first question and answer in that section deals with the aim of the sequential approach, paragraph 23. And I quote, "What is the aim of the sequential approach? The approach is designed to ensure that areas at little or no risk of flooding from any source are developed in preference to areas at higher risk. This means avoiding, so far as possible, development in current and future medium and high risk flood areas, considering all sources of flooding, including areas at risk of surface water flooding. Application of the sequential approach in the plan-making and decision-making process will help to ensure that development is steered to the lowest risk areas, where it is compatible with sustainable development objectives to do so, and developers do not waste resources promoting proposals which would fail to satisfy the test." The italicized words, "where it is compatible with sustainable development objectives to do so," make clear that the sequential test is not an exercise to be carried out in the abstract, without regard to other planning considerations relating to sustainability. Paragraph 27 of the PPG then advises, as part of the response to the question, how should the sequential test be applied to planning applications? It advises, for individual planning applications subject to the sequential test, the area to apply the test will be defined by local circumstances relating to the catchment area for the type of development proposed. For some developments, this may be clear, for example, the catchment area of a school. In other cases, it may be identified from other plan policies. There is no suggestion in this passage or elsewhere in the PPG that when a sequential test is carried out for an individual planning application, the catchment area, in the sense of a reasonable area of search, is always the entire geographical area of the local planning authority. What is required instead is a planning judgment about what the reasonable area of search should be for the type of development proposed, having regard to relevant policies about sustainable development in the development plan. One of the most relevant development plan policies when making a judgment about a reasonable area of search in the present case is the local plan policy that identifies the sustainable settlement hierarchy for the district. Mr. Yarwood agreed in cross-examination that this policy, policy S2 of the local plan, is a necessary consideration if the sequential test is to be carried out, as the PPG instructs, in a manner that is compatible with sustainable development objectives. The first sentence of Policy 2 states, proposals for new development will be directed towards the most sustainable locations in accordance with the following settlement hierarchy. Mr. Yarwood accepted in cross-examination that a sequential test carried out in a way that is compatible with sustainable development objective must take account of the fact that the local plan is seeking to direct new development towards, as is stated here, the most sustainable locations. Policy S2 then identifies the first tier of the settlement hierarchy as including the 3 market towns of Matlock, Ashbourne and Wirksworth. The policy describes these market towns as follows. These are the district's main towns. They are the primary focus for growth and development to safeguard and enhance their strategic roles as employment and service centres. They will continue to provide significant levels of jobs and homes, together with supporting community facilities and infrastructure to meet their economic potential in the most sustainable way consistent with maintaining or enhancing key environmental attributes. When it comes to acting compatibly with sustainable development objectives, therefore, there is a clear basis in the local plan for considering Matlock, Ashbourne and Wirksworth together, as Marans did in their sequential assessment. In their written submissions in response to this sequential assessment, WAG queried why the amalgam of smaller settlements known as Darley Dale had not been included within Maran's area of search. In the local plan settlement hierarchy, Darley Dale is a second-tier local service centre, a tier below the three market towns. This is reflected in the housing allocations that the local plan makes for Darley Dale in policy HC2. The 5 site allocations identified for Darley Dale in the table would collectively deliver 321 dwellings on sites with capacities ranging from 9 dwellings to 135 dwellings. This can be compared with a single allocation that the local plan makes for 430 dwellings on the site. Clearly, when the council adopted this settlement hierarchy for the district as part of the local plan, it did not envisage Darley Dale as a whole, let alone a single site in Darley Dale, accommodating anything approaching the quantum of housing development that it allocated to the site in Matlock. Marans was therefore justified in not including Darley Dale within a reasonable area of search that was focused on first-tier settlements that could conceivably accommodate the quantum of housing development proposed on the site. WAG maintained that if the appellant's sequential assessment included sites as far away as Ashbourne, then it would have been logical, it said, to include sites in Brailsford, Doveridge and Holland Ward. However, Brailsford, Doveridge and Holland Ward are all accessible settlements with some facilities within the third tier of the settlement hierarchy. Policy S2 states that these third-tier settlements, and I quote, will provide for reduced levels of development in comparison to higher-order settlements in order to safeguard and, where possible, improve their role consistent with maintaining or enhancing key environmental attributes. Housing allocations made in policy HC2 for third-tier settlements reflect these reduced levels of development. For example, 3 housing allocations are made for Brailford for 32, 35 and 47 dwellings respectively, with a note at the end of the table explaining that the numbers 35 and 47 are in brackets with a 0 before them because planning permission has already been granted for housing on those sites that is consistent with those allocations. 3 housing allocations are made for Doveridge for 46, 85 and 18 dwellings respectively. 3 housing allocations are also made for Holland Ward for 48, 18 and 33 dwellings respectively. The local plan plainly does not envisage any of these 3 third-tier settlements accommodating anything approaching the quantum of housing, 430 dwellings, allocated for the site in Matlock. The same is true of the settlements of Middleton, 45 dwellings, and Tansley, 19, 27, 49 dwellings, also mentioned by WAG in its submissions. It would be incompatible with the sustainability objectives of the local plan to search for sites in third-tier settlements to accommodate a housing development of over 400 units. WAG also criticised the appellant's sequential assessment for only, it claimed, considering sites within the settlement boundaries of the 3 market towns, rejecting potentially available sites simply because they were located outside the settlement boundary. However, before WAG made that criticism, the appellant had prepared a document, Response to Inspectors' Questions, Flood Risk Sequential Test, explaining at para 2.14 that the table at Appendix 1 to the appellant's original sequential assessment did not include the reasons why sites allocated outside the settlement boundaries of the market towns had been discounted at an early stage. As para 2.14 explained, in many cases these sites were deemed not developable within the Council's 2016 or 2022 Strategic Housing and Economic Land Availability Assessment, or SHELA, for one or more planning reasons related to landscape, biodiversity and or highways impacts, and therefore discounted on that basis in the appellant sequential assessment, or the ST document, at an initial stage. The table contained at Appendix 1 to the ST document has been reproduced and expanded below, Table M1, to identify clearly whether the site considered is inside or outside the adopted settlement development boundaries of the first-tier market towns, and to refer to any relevant conclusions within the 2016 and or 2022 SHELA as to the developability of the site. This confirms that sites outside of settlement limits were initially considered for robustness in the ST document. Table M1 then contained more information about what the Council's recent Shilars had concluded about the developability of the sites considered in the table. As the author of the table, Mr. David Pendle, a partner at Marans, explained in his oral evidence at the inquiry, the information in the column Shilar Outcome 2022/2016 in Table M1 simply reflects what the Council concluded in its own Shilars. It does not reflect any planning judgment by Marans in relation to any of the sites listed. Curiously, WAG did not respond to the additional information set out in the Shilar Outcome column of Table M1, even though it clearly did have regard to aspects of Table M1 for another purpose. WAG's criticism of the approach taken in the sequential assessment to sites outside the settlement boundaries of the market towns related to a previous less detailed version of Table M1 in the original assessment that Table M1 superseded. The upshot is that the information provided in Table M1 about the developability of the sites listed is unchallenged by WAG. To be clear, therefore, the sequential assessment undertaken on behalf of the appellant did consider sites beyond but adjacent to the settlement boundaries of the market towns, and Table M1, prepared with the benefit of more time, then provided more information about whether those sites were considered developable or not in the Shilars undertaken by the Council. WAG's contention in its written submissions that the area of search in the sequential assessment only includes sites within the settlement boundaries of the market towns, the answer is yes, it said, it is factually wrong. On the question of whether the approach taken to smaller sites in the sequential test was consistent with the advice in the PPG, the relevant advice is at para 28 of the PPG on flood risk and coastal change. It states as follows: what is a reasonably available site? Answer: reasonably available sites are those in a suitable location for the type of development with a reasonable prospect that the site is available to be developed at the point in time envisaged for the development. These could include a series of smaller sites and or part of a larger site if these would be capable of accommodating the proposed development. Such lower risk sites do not need to be owned by the applicant to be considered reasonably available. WAG did not see, and I quote, any reason why a series of smaller sites should be linked. According to WAG, it was sufficient if, and I quote, in combination, a series of smaller sites can provide for the housing need. Mr. Yarwood confirmed in cross-examination that WAG did not base this statement on any court judgment or appeal decision. The statement was simply WAG's view on the matter. As the appellant explained in its response to Inspector's questions, flood risk sequential test, that view was mistaken following the judgment of the High Court in the Mead Realisations case, in which the judge interpreted the words series of smaller sites to mean a relationship between sites appropriate for accommodating the type of development which the decision-maker judges should form the basis for the sequential assessment. This addresses the concern that a proposal should not automatically fail the sequential test because of the availability of multiple disconnected sites across a local authority's area. The issue is whether they have a relationship which makes them suitable in combination to accommodate any need or demand to which the decision maker decides to attach weight. End quote. It does not appear that WAG took account of this judgment before asserting that there was no need for a series of smaller sites to be linked. It is now clear that a random collection of disconnected smaller sites should not be regarded as a reasonable alternative proposition in a sequential assessment, simply because collectively they would have capacity for a similar number of dwellings to that being proposed. In any event, as is demonstrated by Table M2 within the appellant's response to Inspector's questions, even if the capacities of the smaller developable sites in the market towns are added together in respect of each settlement, with no regard for whether those sites have any meaningful relationship with each other, the total capacity for each settlement still would not get anywhere close to the up to 423 dwellings that the appellant is proposing on the site. Mr. Yarwood did engage with Table M2, demonstrating that he was aware also of the updated Table M1 with which he did not engage, but argued initially in writing that the calculation for Matlock was incomplete because the capacities for sites 3, 4 and 6 had not been included. He withdrew that argument when it was pointed out to him in cross-examination that sites 3 and 4 were not included in the calculation because they've already been fully built out with housing and so do not have any remaining capacity for the purpose of Table M2. Sites 3 and 4 are clearly not reasonably available sites for the purposes of a sequential assessment. As for Site 6, Mr. Yarwood again conceded in cross-examination that it had been logical not to include Site 6 within the calculation when the council had recently refused a planning application for housing on the site. Despite these difficulties, WAG still asserted that not all reasonably available sites had been considered in the appellant's sequential assessment and made the broad brush criticism that, and I quote, many other sites should have been reviewed, including opportunities for redevelopment of brownfield sites and commercial buildings with potential for conversion. But when asked in cross-examination whether he was able to identify a single specific brownfield site or site containing commercial buildings that should have been considered, Mr. Yarwood was unable to do so. Two further points of clarification should be made in relation to the appellant's sequential test. In its written response to WAG's comments on its sequential assessment, the appellant has corrected the error in section 4 of its original sequential assessment, which led to the two quarry sites, Halldale Quarry and Cawdor Quarry, being labelled the wrong way around. This labelling error did not change the conclusion of the sequential assessment that neither of the quarry sites is sequentially preferable to the site in relation to flood risk. Second, WAG was wrong to say that the appellant's sequential assessment was misleading in stating that the Cawdor Quarry site is partially within flood zones 2 and 3, that should say. It is a matter of fact that parts of the Cawdor Quarry site, as delineated and allocated in the local plan, are within flood zones 2 and 3. There was nothing misleading in the sequential assessment relying on that objective fact. In reality, WAG's point appeared to be that the allocation should not have been drawn in the first place to include the land within flood zones 2 and 3. But that is a very different point that does not provide a basis for alleging that the appellant is misleading the inquiry by relying on the allocation as drawn in the local plan. Mr. Yarwood also accepted in cross-examination that WAG was mistaken in stating that the Cawdor Quarry allocation, and I quote, strays into the middle of the River Derwent. It clearly does not on a correct understanding of the red line boundary of the allocation. Mr. Yarwood rightly accepted in cross-examination that this statement by WAG was incorrect. The appellant is grateful to WAG for pointing out matters that needed to be clarified or corrected in its sequential assessment, but its remaining criticisms of the assessment are without foundation and betray in several respects a misunderstanding of national policy and guidance on such assessments. Council's judgment is that the appellant's sequential assessment, and I quote, is appropriate and the type of exercise that the council would expect to see had the appellant been required to carry out sequential testing at the application stage. The inquiry can have confidence in the conclusion of the assessment that there is no other reasonably available site that is sequentially preferable to the site in flood risk terms. Additional matters raised by Mr. David Ball. The inquiry received a detailed written submission from a local resident, Mr. David Ball, who was concerned about the ability of the gully behind 5 Bentley Close to cope currently with flows from the Wold Spring watercourse that runs through the middle of the Phase 1 land of the proposal. He was concerned that the gully connects to a culvert running under land south of the Phase 1 land, which in his view, and I quote, has serious viability issues and is highly likely to be collapsed in more than one place. He also suggested that the appellant had mismeasured the outlet pipe of the gully behind 5 Bentley Close, undertaking hydraulic modelling on the basis that it has a 150mm diameter, when he has provided a photograph apparently showing, he claims, that it has a 100mm diameter. He claims that the appellant has therefore underestimated the discharge rate of the existing gully by 66%. Mr. Ball's concerns were sincerely held. However, contrary to what Mr. Ball appeared to be suggesting in his oral evidence to the inquiry, his understanding of the facts on the ground, even if assumed to be correct, does not suggest that the development proposed in Phase 1 of the scheme will increase flood risk on the site or in the wider area. It is well known to all parties to the inquiry that the Wold Spring watercourse that runs through the Phase 1 land can cause flooding in the wider locality. This watercourse enters the Phase 1 land at the northern boundary and is currently conveyed and channeled through the Phase 1 land via a depression which is formalised into a watercourse. It travels through the Phase 1 land to a topographical low point immediately north of the southern boundary of the Phase 1 land, behind 5 Bentley Close, and discharges into a culvert that then runs under the back gardens of Bentley Close. The topographical low point within the Phase 1 land, near the outfall point into the culvert, currently provides some informal attenuation of walled spring flows when they exceed the capacity of the culvert. This informal attenuation is shown in a photograph in section 2 of Mr. Ball's supporting information, taken during Storm Babbitt on the 20th of October of 2023. Currently, as Mr. Ball explained, if the watercourse flows increase to the point where this informal attenuation is not sufficient, the excess water is channeled behind the back gardens of Bentley Close into Gritstone Road, collecting at a low point in front of 71 Gritstone Road before it's distributed into the surrounding road network and properties in the area. In the appellant's proposed drainage strategy for the Phase 1 land, the Wold Spring watercourse would enter the site in the usual way at the northern boundary and then run through the site via open ditches and, where necessary, via culverted sections to avoid critical infrastructure, specifically the link road from Phase 1 to Phase 2 and the larger attenuation pond taking runoff from the Phase 1 housing. The watercourse would then discharge into the culvert running under the back gardens of Bentley Close, which is to be retained as the outfall for watercourse flows. Some of the current informal attenuation on the Phase 1 land provided by the topographical low point near the culvert outfall would necessarily be lost in the appellant's proposal for the Phase 1 land due to changes in levels needed in this area to deliver the larger residential attenuation pond. But the appellant has dealt with this loss of informal attenuation by providing an additional attenuation pond near the culvert outfall. This additional pond would have a capacity of approximately 275 cubic metres, which would amount to betterment in comparison to the current informal attenuation. Accordingly, as Mr. Hilton stressed in his oral evidence to the inquiry, the existing flows and discharge points from the Wold Spring watercourse would be maintained by the appellant in line with riparian ownership rights and responsibilities. In addition, there would be an increase in the volume of water attenuated within the Phase 1 land before it overtops into Gritstone Road during more extreme storm events, reducing the extent of flooding in these events, as the appellant's two-flow modelling has confirmed. The appellant notes Mr. Ball's concern that the diameter of the culvert is 100 millimetres, not 150 millimetres. Mr. Hilton and his colleagues at Tetra Tech have relied in good faith on the diameter of 150 millimetres that was identified in the CCTV survey information provided to them in relation to the culvert. Ultimately, however, nothing turns on this, as the existing culvert outfall is to be retained in the appellant scheme, with no changes to the watercourse flows running through this culvert with the Phase 1 development in place. Mr. Ball expressed concern about watercourse flows increasing with the Phase 1 development in place, but there is no evidential or even logical basis for that concern. As both the appellant's drainage expert, Mr. Hilton, and the council's drainage expert, Mr. Keeble, confirmed at the inquiry, the watercourse flows on the Phase 1 land would not increase with the Phase 1 development in place, given the proposed strategy for managing those flows, including in a manner formal attenuation that is not currently done at all on the Phase 1 land. Ultimately, it was difficult to understand Mr. Ball's objection to the appellant's Phase 1 drainage proposals, when those proposals, alongside the further security of draft condition 17, could only be an improvement on the status quo. The appellant and the council agree, and I quote, that sufficient development-related SUS is provided within Phase 1 of the scheme, with the surface water spring flow diversion, basin and downstream connectivity being based on assumed volumes, capacity and discharge rate. That's in the topic-specific statement of common ground on drainage. They also agree that when detailed design proposals for the Phase 1 SUDs are submitted, pursuant to what is currently draft condition 17, there would need to be, and I quote, a robust evaluation of spring flows and likely interactions, again at that juncture, on the basis that whilst off-site flows do not need to be fully mitigated, they do need to be carefully mitigated and managed so that flood risk does not adversely impact development or land downstream. The inquiry can be confident that it will not only be possible to reduce the risk of flooding from the Waldspring watercourse in the appellant's proposals for Phase 1, but that this will be achieved based on the information and modelling presented by the appellant. In conclusion, therefore, the concern that the proposal would lead to unacceptable effects in relation to flood risk or drainage is mistaken and not supported by evidence. The proposal complies with policies S1, PD8 and DS4 of the local plan and paragraphs 161, 181 and 182 of the framework. Issue 2, the effect of the proposed development on biodiversity. As is set out in the topic-specific Statement of Common Ground on biodiversity, the appellant and the council agree that the proposal would not result in a significant loss of biodiversity if planning permission is granted subject to conditions that would ensure the protection and enhancement of the biodiversity assets on the site. Such draft conditions have duly been agreed between the appellant and the council. We refer in particular to draft conditions 10, 11, 12, 13, 23, 24 and 25. Again, WAG did not join the consensus. It made three main points in relation to biodiversity. It claimed first that some of the surveys of species present on the site are out of date. Second, that local residents have observed some additional species on the site over the years that the appellant has overlooked. And third, that the proposal would lead to the loss of hedgerows that have the statutory status of being important hedgerows. On the age of the species surveys, WAG claimed that the full species surveys carried out for badgers, bats, breeding birds, wintering birds and reptiles on the site were out of date, and that any reviews of these surveys commissioned by the appellant in recent years were not sufficient. The appellant's expert ecologist, Mr. Mark Woods, responded to this concern and others in a technical note appended to Mr. John Dickinson's planning proof of evidence. In section 4 of the note, Mr. Woods listed all the ecological surveys undertaken of the site on behalf of the appellant in recent years. He then commented specifically on badgers and bats. He pointed out that an updated badger survey was carried out in 2023. As for bats, an updated ground level assessment was done in 2023 of trees that had been previously identified as having potential for roosting bats. This followed a previous review of the position in 2022. Mr. Wood summarised the outcomes of these updated surveys and assessment as follows, and I quote, "The work confirmed that there would be no changes to the layout, extent and condition of habitats. Badger activity was still present on the site, and the trees with bat roosting potential remained as before in terms of potential." Following the August 2023 walkover carried out for the ecological appraisal update of 2023, aerial surveys were carried out of trees with potential to support roosting bats, and the results of the surveys were appended to the ecological addendum of November 2023, submitted to the council on the 1st of December of that year. Bat and badger surveys have been updated in compliance with the Chartered Institute of Ecologists and Environmental Managers survey guidelines. Mr. Yarwood suggested that this work undertaken to review and update the species surveys, including for badgers and bats, was not an appropriate mechanism. He said that fresh, comprehensive species surveys should have been done again instead. This argument should be rejected for three reasons. First, Mr. Yarwood did not provide any detailed commentary on any of the work done in 2022 and 2023 to review and update the surveys of badgers and bats. He simply invited you, madam, to reject the updated surveys out of hand without engaging with their substantive content. That was not, we say, a reasonable position. Mr. Yarwood adopted this hardline approach in relation to the species surveys, despite accepting in cross-examination that he was not speaking from a position of expertise on this issue, not being an ecologist himself. Finally, far from supporting WAG's case on this point, the CIEM advice note cited by Mr. Yarwood at paragraph 31 of his proof and appended to WAG's statement of case at Appendix 5 states that decisions on how often ecological surveys need to be updated is ultimately a matter of expert judgment for an ecologist. There is no hard and fast rule that surveys must be updated every 3 years as a minimum. Even after 3 years have passed, whether a survey needs to be updated will be subject to an assessment by a professional ecologist. Similarly, when between 18 months and 3 years have passed since surveys were undertaken, there is no obligation to undertake a fresh, comprehensive survey. The note advises that one of the main matters for the professional ecologist to consider in this window will be, and I quote, "the appropriate scope, timing and methods for the update surveys." Necessarily, if the ecologist is advised to consider the scope of any update survey, that must allow for the possibility of not undertaking the full scope of the original survey again, should the ecologist not consider that necessary in their expert judgment. When the badger and bat surveys of the site were reviewed in 2022 and 2023, Professional ecologist applied his expert judgment to the matters identified as considerations in the CIEM advice note, specifically the validity of the previous survey work, the scope and timing of the updating surveys, and the methods to be used in carrying out those updating surveys. WAG had no serious criticisms to make of the appellant's approach to those matters in relation to badgers and bats. As for the remaining species surveys, there were sound reasons for not redoing these surveys entirely again in recent years, as Mr. Woods was able to explain in his technical note. First, breeding bird surveys were carried out in 2016, 2018 and 2020, with each survey generating similar results. When Mr. Woods prepared the ecological addendum in 2022, he was satisfied that a further survey of breeding birds would not have yielded any additional useful information, given the similarity of the results of the previous 3 surveys, and that walkovers he had conducted of the site did not suggest any material change since 2020. Mr. Woods also noted that no birds were recorded to be nesting in the wetland areas or on cattle-grazed pastures. Second, wintering bird surveys were carried out in 2016 and 2017 and revealed a typical assemblage of farmland birds that were associated with terrestrial rather than wetland habitats and were very similar to the summer assemblage. The absence of a rare or scarce species of wintering bird on the site, the low diversity and abundance of species associated with the wetland habitats, and the absence of any change to the wetland habitats since 2017 led Mr. Woods to conclude that there was little justification for repeating the survey work. That conclusion was entirely reasonable given the history. Third, reptile surveys were carried out in 2015, 2016, 2018 and 2020. These 4 years of surveys did not detect any reptiles on the site. As Mr. Woods explained, these results were not surprising given that the presence of cattle on much of the site makes it generally unsuitable for reptiles. As the extent of livestock grazing on the site has not changed since 2020, there was again little justification for conducting an entirely fresh reptile survey, as the site is still as unsuitable for reptiles as it was in 2020. Once more, Mr. Yarwood accepted in cross-examination that WAG did not have expert ecological evidence of its own on which to base a challenge to any of Mr. Wood's expert judgments in relation to the species surveys undertaken and whether they needed to be updated, and if so, to what extent. The judgments made by Mr. Woods on these matters were reasonable and complied with the relevant CIEM guidelines. Additional species observed on the site. The second point made by WAG in relation to biodiversity was that local people have observed certain species on the site, including common lizard, brown hare and hedgehog, that might not have been given due attention by the appellant, it claims. Mr. Woods responded to this point in his technical note as follows, and I quote, WAG referred to a letter from the Derbyshire Wildlife Trust dated the 28th of October 2021, stating that species of principal importance occur on the site and their own surveys support the contents of the Wildlife Trust's letter. Desk studies have been provided by the Trust on 2 occasions, and there are records for common lizard, brown hare and hedgehog in the local area, but not on or in close proximity to site. The Trust have not provided any further evidence of species presence since 2021, and if WAG have submitted records, the Trust have not shared those records or raised any relevant concerns. With regard to birds, several of the species have been identified on the site and assessed in the Environmental Statement chapter. Mr. Yarwood referred in his proof to local residents observing certain species on the site since the appellant undertook its ecological surveys, but provided no evidence of those observations being reported to the Trust for verification and record keeping. Mr. Woods rightly took issue with the evidential value of those observations when no survey evidence has been gathered to substantiate and verify them. Hedgerows. The third and final point made by WAG in relation to biodiversity was to claim that there are important hedgerows with a special legal status on the site which are at risk of being lost. Mr. Yarwood contended that they are important hedgerows because early mapping records show them being part of a field system which existed before 1845. However, Mr. Yarwood did not append any such early mapping records to his proof or identify them in any other way. The existence of such early mapping records was simply asserted. The appellant instructed an expert in archaeology and heritage, Mr. Paul Gajos, to consider this argument by WAG. Mr. Gajos prepared a technical note that was appended at Appendix 2 to Mr. Dickinson's rebuttal proof. In his technical note, Mr. Gajos explained that Section 97(1) of the Environment Act of 1995 enables ministers to make regulations to protect important hedgerows in England. Whether or not a hedgerow is important must be determined according to criteria prescribed in those regulations. The hedgerows regulations of 1997 have been made to this end. Regulation 4 states that a hedgerow is important if it has existed for 30 years or more and meets at least one of the 8 criteria in Part 2 of Schedule 1 to the regulations. The criterion that seems to be relevant to WAG's argument, not that WAG explains this, is the criterion in para 5A of Part 2, which states, the hedgerow, A, is recorded in a document held at the relevant date at a record office as an integral part of a field system predating the Enclosure Acts. The regulations define the relevant date as the 24th of March of 1997. That's the date on which the regulations were made. Guidance published by the UK government titled The Hedgerows Regulations 1997, A Guide to the Law and Good Practice, states that the phrase predating the Enclosure Acts in para 5A that I've just cited should be taken to mean before 1845. In summary, therefore, for a hedgerow to be classed as important under paragraph 5A, it would need to be shown on a document held by a record office as an integral part of the field system that predated 1845. Against that background, Mr. Gajos explained that the archaeological and heritage assessments that were included in the appellant's environmental statement contain between them 3 historic maps that predate the first Ordnance Survey in 1875. Mr. Gajos added that he'd consulted the catalogue of the Derbyshire Record Office and had found no reference to any other historic maps or documents beyond those 3 historic maps that show or describe the field pattern on the site before 1845. Mr. Gajos went on to analyse the 3 historic maps in his technical note. First, the earliest detailed mapping covering the site, the Matlock Enclosure Map of 1784, does not show any detail as to the field system within the site. It does not, therefore, says Mr. Gajos, provide any evidence to show that the current field pattern preserves any elements of the pre-1845 field system. Second, the earliest dated map showing the field system within the site is the Matlock Tide Map of 1848. Clearly, a map produced in 1848 cannot, according to Mr. Gajos, be used to demonstrate the existence of the field pattern on or before 1845. Third, a third map showing the eastern part of the site, a plan showing the wall spring in the township of Matlock and its courses, is undated, but WAG asserted that it was prepared circa 1830. However, an article from the Derby Mercury newspaper dated the 30th of November of 1859, provided by WAG, referred to the future construction of an aqueduct main pipe connecting the walled spring to the north of the site and a new reservoir at the southeastern corner of the site. As the undated map does not show this aqueduct, Mr. Gajos concluded that it could have been drawn in any year up to 1859, i.e. up to 14 years after 1845. Ultimately, Mr. Gajos concluded that the fact that this map was undated rendered it of no use in demonstrating the pre-1845 field system of the appeal site. Assessing all this historical evidence in the round, Mr. Gajos concluded that there was, and I quote, no documentary or cartographic evidence held in a public record office to show that any hedgerow within the appeal site marks the boundary of a pre-1845 field system. As a result, none of the hedgerows within the appeal site can be classed as important under para 5A of the hedgerows regulations of 1997. Mr. Yarwood could not mount a serious challenge to any of these considered conclusions. A late attempt at the inquiry by WAG to rely on evidence of its recent communications with the Derbyshire Record Office was not fruitful, with Mr. Yarwood fairly conceding in cross-examination, we're not there yet in getting this evidence over the line. The inquiry can safely conclude that it has not received evidence from any party that should lead it to conclude that any of the hedgerows on the site are important for the purposes of the hedgerows regulations of 1997. In conclusion, on issue 2, there is no basis for the concern that the proposal would lead to unacceptable effects on biodiversity. The proposal complies with policy S1, PD3 and PD6 of the local plan and paragraphs 187 and 193 of the framework. Issue 3, the effect of the proposed development on the character and appearance of the area. The appellant and the council agree that planning conditions can address the concerns that underlay the council's original third reason for refusal about whether the surface water attenuation features serving the outline part of the scheme and the link road crossing the valley can be delivered in such a way as to avoid unacceptable effects on the character and appearance of the area. The Council has also confirmed in its opening submissions that whilst it might not agree with every assessment of effect in the appellant's Landscape and Visual Impact Assessment, or LVIA, it does not consider that any of these differences of judgment would lead it to conclude that the proposal would have unacceptable landscape and/or visual effects. For WAG, Mr. Yarwood made a series of points relating to this issue under two main headings: landscape impact and design. Landscape impact. Mr. Yarwood made the high-level claim that the proposal would have a severe and unacceptable impact on the local landscape because this is, he says, an exposed site at a relatively high altitude and provides the scenic backdrop to the town. He accepted in cross-examination that this claim was not based on an alternative LVIA of the effects of the proposal or even a detailed critique of the appellant's LVIA. It was simply his contention as a planning consultant, without any specific qualifications himself, in landscape and visual impact assessment. The contention that the proposal would have a severe and unacceptable impact on the local landscape cannot be reconciled with the principle of the development of the site for 430 dwellings having been established in the extant local plan, Policy HC2, after an independent examination process. The appellant's proposal for up to a total of 423 dwellings is clearly within the scope of the allocation. The contention that the proposal would have a severe impact on the local landscape is also disproved by the technical LVIA work provided in relation to the planning application, specifically first the original LVIA by Munro and Witten that was included as at Appendix 6.1 to the environmental statement, and the addendum LVIA prepared by Urban Wilderness. Turning to the original LVIA first, its summary of the conclusions of the LVIA was as follows. Overall, the scale and form of the proposed development is likely to result in a slight moderate change at a localized level in this area of the Settled Valley Pastures LCA, and on balance, the potential landscape and visual effects identified are likely to be of substantial significance only in the immediate vicinity of the site, receding to moderate and slight impacts as distance increases away from the site. Furthermore, the proposal for green infrastructure and landscape design will deliver a number of enhancements in terms of the physical landscape, end quote. The LVIA work that led to this conclusion included a modified zone of theoretical visibility of the proposal at figure 10 of the original LVIA. As the LVIA explained, and I quote, a computer model of the 3-kilometre study area produced a modified zone of theoretical visibility based on the topographical OS data for the study area. It was modified to take into account buildings and woodland mapped by the Ordnance Survey, which further impedes visual access across the study area. Potential views were selected along the public highway and public rights-of-way within the ZTV. Specific locations were chosen adjacent to places of education, play, recreation or sport, where the view is considered to be one of the reasons for visiting or being at the location. The modified ZTV shows patches of theoretical visibility, coloured purple, in the area immediately surrounding the site and also closely to the east of the site. In the areas to the north of the site beyond its immediate surroundings, it is striking that the proposal would not be visible at all due to the topography and intervening woodland. Again, from the areas to the west of the site, with the exception of land immediately west of the site, the theoretical visibility of the proposal would be very limited due to intervening development and the topography of the land. The built-up settlement of Matlock itself and Matlock Bath is immediately south of the site. Again, the modified ZTV shows that there will be very limited theoretical visibility of the proposal within the built-up limits of Matlock itself because of intervening development and the topography of the land. Whilst there are relatively large patches of theoretical visibility further to the south, southwest and southeast of the built-up limits of Matlock, these are generally well over a kilometre away from the site. The modified ZTV supports the conclusion reached in the LVIA that landscape and visual effects are, and I quote, likely to be of substantial significance only in the immediate vicinity of the site, receding to moderate and slight impacts as distance increases away from the site. There is a viewpoints plan at figure 11 of the LVIA with a more focused viewpoint plan at figure 12, concentrating on the views closest to the site, specifically the views numbered 1 to 5 and 17. Photographs of these viewpoints have been included in the LVIA. A review of these photographs enables the reader to appreciate that the proposal would lead to significant changes in landscape and visual terms from viewpoints 1 to 5, an outcome that would be expected given that all of those viewpoints are located immediately outside the red line of the application site, looking into the site. However, the photograph of viewpoint 6, which is located further away, some 625 metres to the east of phase 1 of the site, enables the reader to appreciate that from more distant viewpoints, the viewer would see the development on the site in the context of the development that is already present within the built-up limits of Matlock, including the extensive residential developments on the slopes immediately south and southeast of the site. As the distance between the viewpoint and the site increases, I refer here to viewpoint 7, 10A to D, 11, 12, 13, 14 and 15, the extent to which the proposed development would make a notable or even discernible difference to landscape character or the visual experience of the landscape reduces further. Chapter 6 of the appellant's environmental statement summarise the conclusions of the LVIA as follows. In conclusion, the proposed development extends the northern urban fringe of the town of Matlock on the upper middle slopes of the Derwent Valley. It establishes an environmentally sustainable edge to the settlement and is defined by and set within the existing framework of woodland on high ground to the north and woodland belts extending down from higher ground to the west. Its visual impact is moderate when seen from afar, and these, as well as substantial moderate adjacent views, can be mitigated within the design of the proposed development. The form of the proposed development means that the extension to the town can be integrated in a visually constrained manner, end quote. This is an accurate and measured summary of the landscape and visual effects of the proposal, which WAG could only challenge with high-level assertions to the contrary. These assertions did not demonstrate that the technical conclusions of the LVIA were incorrect or otherwise open to serious criticism. The purpose of the addendum to the environmental statement that was prepared by the landscape consultancy Urban Wilderness was to check if the conclusions of the original LVIA were still sound after changes were made to the proposal after the original LVIA was completed. These changes to the proposal were outlined in paragraph 3.8 of the addendum and included, amongst others, an increase in the proposed number of dwellings from 415 to up to 423, the enlarging of some of the surface water attenuation basins, and an increase in the area of grassland proposed within the countryside park. The addendum concluded that, and I quote, the baseline situation and the current proposals and mitigation remain fundamentally the same as those reported within the original LVIA, with the conclusions of the original ES chapter LVIA remaining relevant to the updated application. Local objectors can therefore be reassured that the inquiry has before it an update to the original LVIA, which has taken account of the proposed enlarging of some of the surface water attenuation basins within both the detailed and outlined phases of the proposal. That update did not lead to any change in the impact assessment undertaken in the LVIA. Mr. Yarwood suggested in his proof that, and I quote, more recent and more robust analysis of the landscape impact demonstrates that the allocation of this site did not have sufficient regard to this impact. However, it remains the case that the only technical LVIA assessments of the effects of the proposal on this allocated site are the original LVIA and addendum LVIA prepared on behalf of the appellant. It seems that when Mr. Yarwood referred to a more recent and more robust analysis, he had in mind comments made by Derbyshire County Council's landscape officer in their consultation response on the appellant's planning application, cited at paragraph 4.5 of Mr. Yarwood's proof. In particular, Mr. Yarwood seized on the landscape officer's comments, first, that development on the site has the potential to cause the visual expansion of Matlock to the highest slopes of the Derwent Valley out of character with the overall settlement pattern that is currently confined to lower value slopes, and second, that the, and I quote, scale of the site is such that there is the potential for significant adverse visual impacts to the wider landscape, including views from a larger number of sensitive locations, end quote. In these comments, the landscape officer was commenting only in general terms on the potential for the site to be developed in an unsympathetic way, and was not in fact commenting on the appellant's proposal, still less advising that the appellant's proposal would realise that potential. Mr. Yarwood read far too much into this consultation response that was not supported by the words that the officer used. As for Mr. Yarwood's contention that the proposal would have an over-engineered layout, a criticism that seemed to be directed mainly at the outline phases of the scheme, That is not a fair criticism when the latest illustrative master plan shows that the indicative pattern of development in the outline phases, and indeed in the detailed phase, has been informed by the existing landscape pattern of small to medium irregular fields, largely defined by hedgerows and trees, and intersected by an internal road. This pattern of development would be consistent with the pattern of development immediately south of the site, as the illustrative master plan shows. The illustrative master plan also shows that the proposed orientation of the houses, both detailed and indicative, would respond to the existing field pattern. Contrary to Mr. Yarwood's suggestion in his proof, the houses would not have a uniform orientation imposed rigidly on the site. The proposed detailed and indicative layout takes account of the existing field layouts and the topography of the land in the same way as the existing residential development south of the site already does, and this is especially true of the existing residential development immediately south of the detail phase of the proposal. In any event, the adjective over-engineered is particularly ill-suited to describe the proposal when it includes a large and wide area running through the north and centre of the site, following the natural gradient of the land that is proposed to be used as a countryside park. This countryside park certainly does not contain, as Mr. Yarwood puts it, long straight rows of houses. The countryside park will, by definition, provide relief from the residential development proposed either side of it. Mr. Yarwood also took issue with what he described as the relatively large attenuation ponds on both the upstream and downstream sides. But the illustrative master plan shows that there is a clear logic to the indicative location of these attenuation basins in responding to the gradient of the valley and the flow path of water down the valley. Basins in these locations would not significantly shift the existing flow path of surface water down those slopes in an artificial way. As for Mr. Yarwood's claim that, and I quote, levels indicate that a retaining wall of over 4-metre height will be required on the downstream side of the internal road as it crosses the countryside park, the appellant explained at the inquiry that the Phase 2 Attenuation Ponds 1 to 4 Sections Locations Plan was erroneous in showing a 4-metre level difference in this location immediately north of Balancing Pond 3. This was corrected and fully explained in the note of correction by the appellant relating to CD 9.5, provided alongside a corrected plan showing only a 2.52 AOD difference between the level of the access road and the lowest point of the land immediately north of Balancing Pond 3. Mr. Yarwood accepted this correction and did not suggest that a 2.52 AOD level difference between these points as distinct from 4 metres would be problematic. The appellant would add that when the attenuation basins are designed in detail, there will be the opportunity to frame them with soft landscaping features, including trees and hedges, both existing and new, enabling the presence of the basins in the landform to be softened by landscaping that is characteristic of the area. It would also be possible to plant vegetation on the bank to further support the integration of the basins into the landscape, as the appellant's expert landscape architect, Mr. Steve Fraser, confirmed in a technical note. In any event, even though the appellant is convinced that it will be possible to design the countryside park so as to enhance the landscape character of this part of the site, it bears repeating, drawing on the modified ZTV and the original LVIA, that the visual envelope of the countryside park will, in general, be very limited to those with direct views of it in the immediate vicinity. Design. Mr. Yarwood made a series of wide-ranging points about design, all of which the appellant answered convincingly at the inquiry. First, Mr. Yarwood was wrong to suggest in relation to the detail part of the scheme that, and I quote, the absence of cross-sections and finished road and floor levels makes it impossible to assess whether reasonable street gradients can be achieved and how the development will impact on the amenity of and visual relationship with existing and proposed properties. In his main proof of evidence, Mr. Dickinson cited various sources of evidence where information about ground levels on the Phase 1 land can be found, alongside the actual and parameter heights of proposed Phase 1 buildings. In particular, towards the end of paragraph 7.40, he referred to 2 drainage layout plans annexed to the environmental statement, Drainage Layout Sheet 1 and Drainage Layout Sheet 2, which show the assumed finished floor levels of houses in Phase 1, as well as the levels for road contours and drainage infrastructure. Contrary to Mr. Yarwood's claim, the appellant has provided information that enables the inquiry to understand the relative differences in finished floor levels between different components of the detailed parts of the scheme. In any event, as Mr. Dickinson explained in his main proof of evidence, should the issue of finished floor levels on the Phase 1 land be of any concern, A planning condition could be imposed requiring the submission of proposed finished floor, eaves and roof levels for the houses, along with detailed levels for the proposed roads and attenuation basins for both the detailed and outline parts of the scheme. Draft conditions to this effect are proposed. I refer to draft conditions 14 and 20. Mr. Yarwood had a specific concern that, I quote, the floor levels of some, if not all, of the proposed houses on plots 70 to 78 will have floor levels at the same height or significantly higher than the eaves levels of the existing houses on Gritstone Road, adversely affecting, he claimed, the amenity of those existing houses. However, when the position is verified on the relevant plan, specifically Drainage Layout Sheet 2, zooming in on plots 70 to 78, it is clear that the ridge, as distinct from the eaves levels of the existing houses on Gritstone Road to the southeast, are all higher than the assumed finished floor levels for plots at 70 to 78. Two further points need to be appreciated when assessing the acceptability of the relationships between plots 70 to 78 and the existing houses on Gritstone Road to the southeast. First, plots 70 to 78 would all have long back gardens relative to the overall depths of those plots and the footprints of the dwellings proposed within them. Moreover, on the other side of the red line boundary to the southeast, the existing properties on Gritstone Road that are directly in front of plots 70 to 74 also have relatively generous back gardens that will help to retain a sufficient feeling of separation between those dwellings and the houses proposed on plots 70 to 74. The position is different in relation to plots 75 to 78 because the Gritstone Road properties on the other side of the red line boundary are much closer to that red line. However, this has been considered in the design of Phase 1 by proposing single-storey bungalows on plots 75 to 78 rather than the semi-detached dwellings proposed on plots 70 to 74. The design of the dwellings proposed in the far southeastern corner of Phase 1 has taken due account of their relationships with the dwellings on the other side of the site boundary to the southeast. The second point that needs to be appreciated is that the appellant is proposing to install a screen of planting extending the full length of the southeastern boundary of the sites from plots 58 to 78 and beyond. This screen is marked on the relevant plan screen planting as being 5 metres in width. Mr. Yarwood did not appear to have taken account of this proposed screen before alleging that the houses on plots 70 to 78 would have an adverse impact on the residential amenity of those living in existing properties on the other side of the site boundary. Second, Mr. Yarwood paid particular attention in his brief to the bungalow proposed on plot 78, referring to a street elevation cross-section that had been included in WAG's statement of case, with the bungalow proposed on plot 78 superimposed onto it. Mr. Yarwood suggested that it might not be possible to achieve access to the rear of that bungalow, and I quote, without substantial retaining walls and or numerous steps. The appellant cannot verify the accuracy of the cross-section in WAG's statement of case as it did not prepare it. However, the appellant's own information about floor levels in this area, as recorded on the plan discussed above, is that plot 78 has an assumed finished floor level of 226.2 metres AOD, with a rear garden of approximately 15 metres in length behind it. Over the length of those 15 metres, there would be a drop in level from approximately 225 AOD right behind the dwelling to a level of 223 AOD at the rear of the garden. A drop in levels of 2 metres over a 15-metre distance would not result in the rear of the dwelling becoming inaccessible from the rear garden. In any event, draft condition 14 would enable the finished floor level of the rear garden of plot 78 to be approved by the council prior to the commencement of development, should the inspector consider that the accessibility of the rear access to the dwelling on plot 78 could be improved by tweaking that finished floor level. Third, Mr. Yarwood suggested that there was, and I quote, an absence of detail to explain how the significant difference in the level between the balancing ponds in Phase 1 and the houses on the northwest side of Bentley Close will be resolved. Mr. Yarwood noted that a drainage drawing showing this being achieved by a gabion wall, whereas a landscape plan showed a retaining wall in this location. Whichever means would be used, Mr. Yarwood considered it would have a significant impact on trees and hedgerows in the gardens of the adjacent houses. In his planning proof, Mr. Dickinson explained that these plans had used the terms gabion retaining wall interchangeably, a gabion wall being a type of retaining wall. However, his more fundamental point was that a gabion retaining wall should not have been retained on these drawings, that it is no longer required. As Mr. Dickinson explained, and I quote, drawing number 501P03, i.e. the drainage drawing, shows a red rectangle with circles extending between the two balancing ponds on phase 1. This feature was originally intended to represent a proposed gabion wall, but this was retained on the above drawing in error, and it is unlikely to be required for the southern basin, given that this includes internal batters at a ratio of 1:3 and standoff from the southern boundary of phase 1. The detailed design of the attenuation basins and associated infrastructure can be dealt with by planning condition. WAG can therefore be assured that no gabion wall is in fact proposed in this location. Mr. Yarwood still expressed a residual concern about works carried out in the vicinity of the most southern balancing pond in phase 1 having an impact on trees and hedgerows in the gardens of the adjacent houses on Bentley Close, in particular tree 38 in the garden of 5 Bentley Close, which is shown for removal on the vegetation retention and removal plan. Again, Mr. Dickinson answered this point fully in his proof, explaining that a cartographic error had led to this drawing showing the removal of T38. He returned to the point in his rebuttal proof, attaching at Appendix 3 to that rebuttal an updated version of the vegetation removal, retention and removal plan, corrected to show T38 being retained in the rear garden of 5 Bentley Close. Also attached at Appendix 4 to Mr. Dickinson's rebuttal proof was an arboricultural technical note prepared by Mr. Stephen Webber. Section 3.2 of this technical note referred to drawing 323 UWP 07 Rev I landscape proposals, sheet 4 of 4, also attached at Appendix 3 to Mr. Dickinson's rebuttal, which shows a grassed path on the south side of the attenuation basins in phase 1, along with refined landscaping proposals after removing the gabion retaining wall. As Mr. Webber concluded in his technical note, and I quote, the proposed ground level changes associated with the balancing pond works would not have unacceptable adverse impacts on trees and hedgerows within the rear gardens of Bentley Close. This can be assured through the implementation of robust mitigation measures during construction in accordance with British Standard 5837. The mitigation measures and associated documentation can be secured by way of suitably worded planning condition. Draft Condition 11 would provide such a condition in relation to phase 1 of the scheme. Mr. Yarwood fairly conceded in cross-examination that WAG had no technical evidence of its own from an arboricultural expert to challenge the expert judgments of Mr. Stephen Webber in his technical note. Fourth, Mr. Yarwood made a series of high-level assertions about the design of the proposal by reference to paragraphs 135 to 137 of the framework and the National Design Guide. On the whole, these points were made at such a high level of generality, for example, saying that the proposal would not function well or add to the overall quality of the area, that they do not warrant a considered response in these closing submissions. However, the appellant would respond as follows on the following 2 matters. First, the appellant suggested that Mr. Yarwood, suggested that the detailed and indicative layout of the proposal, and I quote, is not pedestrian friendly, but is designed to give priority to the movement of vehicles, end quote. This criticism is neither fair nor accurate when the illustrative master plan shows extensive pedestrian-friendly routes through the north and centre of the site via the countryside park, and further pedestrian routes through the built development, including in the detailed phase 1 of the scheme. Second, Mr. Yarwood's claim that there are, quote, rows of parking spaces dominating the street scene, end quote, in phase 1 of the scheme is also unfair and inaccurate. The illustrative master plan does not depict long rows of parking spaces in phase 1. It depicts parking spaces distributed appropriately in front of dwellings, regularly separated by front gardens and street trees. The parking layout is a familiar and entirely acceptable layout arrangement for a large housing site. Fifth and finally, Mr. Yarwood considered that provision should not be made on the site for a sui generis hot food takeaway use, as is proposed as part of the scheme, because it would be within walking distance of a school, contrary to paragraph 97 of the framework. This argument seems to raise a discrete issue of policy application, rather than one coming under the general umbrella of design, but the appellant is content to deal with it here for convenience. Paragraph 97A of the framework states that local planning authorities, quote, should refuse applications for hot food takeaway and fast food outlets, A, within walking distance of schools and other places where children and young people congregate, unless the location is within a designated town centre. The glossary to the framework defines town centre as including, amongst other types of centre, local centres, but excludes small parades of shops of purely neighbourhood significance. Policy DS4 of the local plan states that the allocation of the site for a residential-led mixed use includes the provision of, quote, a local centre proportionate in size to serve the needs of future residents of the site. The appellant considers that it is proposing a local centre as part of its scheme, as does the council, and that the extent of Class E uses proposed within this local centre would amount to more than a small parade of shops of purely neighbourhood significance for the purposes of paragraph 97 of the framework. Accordingly, the provision of a sui generis hot food takeaway use within the scheme would not be contrary to paragraph 97A of the framework, as it would be located within a local centre, which is a type of town centre, as that term is defined in the framework. Nevertheless, the appellant is not wedded to the provision of a sui generis hot food takeaway use within the scheme. Should you, Madam, conclude that the scheme should not include such a use, the appellant would not resist a condition being placed on the planning permission restricting the local centre uses to Class E commercial uses only. In conclusion, on issue 3, the proposal would not have or lead to unacceptable effects on the character and appearance of the area. The proposal complies with policies S1, S7, PD1, PD5, PD6, and DS4 of the local plan, and section 12 of the framework. Issue 4, the effect of the proposed development on highway and pedestrian safety. The local highway authority, Derbyshire County Council, has no objection to the proposal, subject to necessary conditions and obligations, including a Grampian condition to secure the relocation of the signalled pedestrian crossing across Chesterfield Road. Such a condition has been agreed in draft between the appellant and the council. I refer to draft condition 15. The signalled pedestrian crossing across Chesterfield Road currently provides a crossing point to Highfield School. As is shown on the A632 Gritstone Road Wolds Road Improvements Plan, the crossing is currently located a short distance northeast of the junction of Chesterfield Road and Wolds Road. As this relatively wide junction would be used by construction vehicles when this scheme is being built, there is an understandable desire to avoid the need for pupils to cross Wolds Road as they walk to and from Highfield School, which tends to happen with the pedestrian crossing in its current location. The proposed improvement is to relocate the pedestrian crossing to the southwest so that it is on the other side of the junction between Chesterfield Road and Wolds Road. This would enable pupils walking to and from the school along Wolds Road to avoid having to cross Wolds Road close to its junction with Chesterfield Road. On their walk to the school, they would walk down Wolds Road, use the relocated pedestrian crossing across Chesterfield Road without having to cross Wolds Road, and then walk along the new, wider footway to school. They would follow the same route in reverse on their way home from school, again avoiding the need to cross Wolds Road. The appellant and the local highway authority agree that this new pedestrian route would be safer for pupils, not only during the construction of the scheme, but beyond then also, given that the need to cross Wolds Road close to its junction with Chesterfield Road is avoided. For WAG, Mr. Yarwood suggested that there were two main problems with this proposal. First, he was concerned about the implications of relocating the crossing for pedestrian safety. However, his proof did not go beyond an assertion that relocating the crossing would, and I quote, create several problems in terms of safety, which he did not then identify. When asked about this in cross-examination, he explained for the first time that the problem, singular, he saw with this approach was that it could lead to pupils on their walk home from school queuing along the new footpath along Chesterfield Road whilst waiting to use the relocated pedestrian crossing. He was concerned that some pupils can be tempted to avoid the queue by simply crossing Chesterfield Road without using the new pedestrian crossing, creating a safety risk that does not yet appear to have been considered, he claimed. It is important to stress that the proposal to relocate the crossing is not being driven by the appellant in isolation. It is being required by the local highway authority, which has the overall supervision of all matters of highway safety in the county. Highway safety necessarily includes the safety of children and young people, as well as adults. The local highway authority is requiring the relocation of the crossing precisely because it considers that it will make the pedestrian journeys of pupils to and from the schools safer if the site is developed as proposed. Moreover, the works to relocate the crossing will be the subject of an agreement between the appellant and the local highway authority under Section 278 of the Highways Act of 1980, the need for which would be secured, as I've explained, by a pre-commencement condition. Section 278 agreements typically require staged road safety audits to be submitted and approved by the local highway authority to ensure the safety of the public highway and its users during and after construction. In the present case, these road safety audits would identify any additional safety measures that are needed to secure the footway. For example, the potential use of protective metal guardrails along the footway of the kind that are commonly seen along roads in the vicinity of schools to prevent pupils from trying to cross Chesterfield Road before the crossing. The issue of pedestrian safety would receive rigorous attention from both the appellant and the local highway authority during the road safety audits process. There is no reason to think that the audits process would not deal robustly with the issue of pedestrian safety in the context of this being a route used by young people. It should also be highlighted that the appellant and the council have agreed the wording of a draft condition that would prohibit deliveries being taken at or dispatched from the site before 9 a.m. or after 3 p.m. Monday to Friday, or before 9 a.m. or after 1 p.m. on Saturday, to avoid any potential conflict between delivery vehicles and young people walking to school. I refer to draft condition 34. The second problem with the proposed relocation of the crossing, according to Mr. Yarwood's proof, is that it's not possible to secure an off-site highways improvement on land not controlled by the developer by using a pre-commencement condition requiring entry into an agreement under Section 278 of the Highways Act. However, Mr. Yarwood promptly abandoned that argument in cross-examination, accepting that it is well established that this is not only possible, but standard practice. His argument, he clarified, was that a Section 278 agreement shouldn't be used to secure the relocation of the crossing due to his concern about pedestrian safety, not that it couldn't lawfully be done. That concession was properly made, as the PPG on the use of planning conditions confirms. Question: when can conditions be used relating to land not in control of the appellant? Answer: conditions requiring works on land that is not controlled by the applicant or that requires the consent or authorization of another person or body often fail the tests of reasonableness and enforceability. It may be possible to achieve a similar result using a condition worded in a negative form, a Grampian condition, i.e. prohibiting development authorized by the planning permission or other aspects linked to the planning permission, for example, occupation of premises, until a specified action has been taken, such as the provision of supporting infrastructure. Such conditions should not be used where there are no prospects at all of the action in question being performed within the time limit imposed by the permission. In conclusion, on issue 4, the inquiry can be assured that the proposal would not have unacceptable effects on highway or pedestrian safety. The proposal complies with policies S1, S3E, HC18, HC19, HC20 and DS4 of the local plan, and paragraphs 115 and 118 of the framework. Issue 5, whether the proposed development would make an appropriate contribution towards affordable housing need. Viability experts appointed by the appellant and the council respectively agree that the proposal cannot viably provide any affordable housing. WAG did not seek to challenge the consensus reached by the experts in relation to viability. Nevertheless, Mr. Yarwood expressed concern that the non-provision of affordable housing in the appeal scheme for viability reasons would mean that the proposal would not be making any contribution to meeting the council's affordable housing needs. However, policy 8C4 of the local plan allows the developer to provide a level of affordable housing that is below the requirements of the policy, including no affordable housing at all, if that is justified by evidence on financial viability. As the fourth paragraph of policy HC4 states, where the proposed provision of affordable housing is below the requirements set out above, the District Council will require applicants to provide evidence by way of a financial appraisal to justify a reduced provision. The possibility of being able to justify a reduced provision of affordable housing on viability grounds is built into the policy, with no suggestion the reduction to 0 is incapable of being justified. The scheme is not therefore in breach of policy HC4 of the local plan on the ground that it cannot viably support any affordable housing. To the contrary, the scheme complies with policy HC4 because the non-provision of affordable housing has been justified by robust evidence. As discussed at the inquiry, the draft Section 106 agreement makes default provision for a mechanism to review the viability of providing affordable housing within the proposal. It remains the appellant's case that this review mechanism is not necessary to make the proposal acceptable in planning terms due to the total absence of any requirement for such a viability review in the council's local plan. In these circumstances, the PPG on viability is clear that a viability review mechanism that has not been tested at a local plan examination should not be required when determining individual planning applications. The appellant has already made detailed written submissions in support of its objection to the viability review mechanism on legal grounds, which I need not repeat here. Suffice to note that the appellant renews its invitation to you, Madam, to conclude in your decision that the viability review mechanism in the Section 106 agreement is not required and should therefore, pursuant to Section 11 of the Section 106 agreement, cease to have effect as it does not comply with the necessity test in Regulation 122 2A of the Community Infrastructure Regulations 2010. I pause there, Madam, just to make and this will be the only additional comment that I make orally in this closing, to respond to submissions made by the council at paragraphs 21 and 22 of its closing submissions, where the council sought to highlight passages in the Harrow and Stockport appeal decisions that I cited in my legal submissions on the viability review mechanism, highlighting passages in those decisions that refer to those schemes being single phase schemes. The only point I make in response to that, Madam, is that the citations in paragraph 21 and 22 are incomplete. And the key word in both citations is moreover. In both of those cases, the inspectors said moreover, because prior to that, they had already decided that a viability review mechanism was not necessary because of an absence of a requirement for a review mechanism in the development plan. That was the basis upon which both of those decisions were made by those inspectors on that issue. So the moreover observations that are cited in paragraphs 21 and 22 of the council's closing submissions were essentially secondary observations made in further support of a judgment already reached. And that judgment was based on what was, or rather what was not, in the development plan.
Thank you, Mr. Lewis. Just to confirm to both the council and the appellant in this, I have already read those appeals, the Harrow and Stockport decisions. I will go back and reread them again in the light of both closings.
I'm most grateful, Madam. Thank you. I will return to my written closing, and we're now at issue 6, whether the proposed development would make appropriate contributions towards community and infrastructure needs. At the time of writing, a Section 106 agreement between the landowner, the appellant, the District Council and the County Council, securing full financial contributions for the sums requested by the councils, is being circulated between the parties for their signature. A final signed version of the agreement will be provided to the case officer at PINS at the earliest opportunity. All parties are aware of the importance of signing the agreement promptly. The draft version of the Section 106 agreement indicates that in the event of planning permission being granted for the proposal, financial contributions will be secured for the following: £423,000 to the District Council to be used for projects to extend the Lime Grove Medical Practice or Imperial Road Surgery, or to construct a new medical practice within the Matlock administrative area to meet the needs of the development. 267,000 to the County Council to be used for area-wide travel plans, 410,000 to the County Council to be used to upgrade existing bus stops on Chesterfield Road, close to Wolds Road Junction, and to enhance the existing X17 bus service. A maximum of £289,332 to the County Council to be used as a budget for 2 bus passes per dwelling. £29,809 and a little over to the County Council to be used to fund improved library provision in Matlock necessitated by the development. £1,115 to the County Council for the costs incurred in monitoring compliance with the Section 106 agreement. £1,014,980 to the County Council towards providing additional educational facilities at Castle View Primary School to meet the needs of the development. £86,204 to the County Council to fund improvements to the Sandy Lane public right-of-way to mitigate the effects of the increased use of the public right-of-way as a result of the development. £672,929 to the County Council to provide additional educational facilities at Highfield School to meet the needs of the development. £343,945 to the County Council to provide for additional SEND places to meet the needs of the development. £7,500 to the County Council towards its administrative costs of managing the travel plan for the development, and £10,560 to the County Council towards its costs of monitoring compliance with the travel plan obligations. SIL compliance statements have been prepared by both the district and county councils to explain why these financial contributions comply with the tests in Regulation 1222 of the SIL regulations. The appellant is satisfied that the councils have justified those contributions, and WAG does not suggest otherwise. As soon as the Section 106 agreement is signed by all parties, the proposal will comply with local plan policies S10 and DS4 in relation to developer contributions, as well as the Council's supplementary planning document on developer contributions, by making all necessary contributions towards community and infrastructure needs. And so I turn finally, I'm sure everyone will be pleased to hear, to the planning balance. First, I'll deal with the mini heritage balance. The allocation of the site for housing in policy DS4 of the local plan states that any development proposal brought forward pursuant to the allocation should consider the impact of the development on the setting of heritage assets, including the setting of the Grade 2 listed Wolds farmhouse and the identification of appropriate mitigation measures. The historic environment chapter of the environmental statement states that the, forgive me, I'll start that again. The historic environment chapter of the environmental statement that the appellant provided with its planning application included a thorough review of heritage assets in the vicinity of the site. It concluded that only in the case of the Grade 2 listed Wolds farmhouse would there likely to be any noticeable effects during construction and operation. The main statement of common ground between the appellant and the council records their agreement that the proposal would cause less than substantial harm to the setting of Wolds farmhouse, and that this degree of harm with appropriate mitigation will be outweighed by the public benefits of delivering housing to help meet the district's housing needs. It also records their agreement that, subject to conditions to control the appropriate identification and recording of below-ground archaeology, the maintenance of landscape features, and the delivery of an appropriate buffer between the development and Wolds farmhouse, the proposed development will not result in unacceptable adverse effects in relation to the historic environment. In examination in chief, in response to a query from you, Madam, Mr. Dickinson stated that he considered the degree of less than substantial harm to be towards the lower end of that spectrum, and that this judgment was consistent with the assessment of the impacts of the proposal on the setting of the Wolds farmhouse in the historic environment chapter of the environmental statement. WAG presented no case in relation to Wolds farmhouse or any other heritage asset. The appellant invites the inspector to agree that the proposal will lead to harm to the setting of the Grade 2 listed Wolds farmhouse at the lower end of the less than substantial harm spectrum, and that this harm with mitigation would clearly be outweighed by the public benefits of the proposal, principally the delivery of up to 423 houses in a district with an extremely low housing land supply of only 1.36 years. and so to the overall planning balance. As I noted, the appellant and the council are agreed that the appeal should be allowed, the only caveat to this agreement being that the council, unlike the appellant, considers that a viability review mechanism in the Section 106 agreement is necessary. Subject only to the resolution of that point by you, Madam, the council's case, as confirmed by Mr. Paul Instone in his planning proof for the council, is that the proposal, quote, complies with an up-to-date development plan, and that paragraph 11C of the framework is engaged, and that the appeal proposal should be approved without delay. That was also Mr. Dickinson's assessment on behalf of the appellant. As Mr. Yarwood fairly accepted in cross-examination, he did not provide any evidence on behalf of WAG in relation to the planning balance. In essence, WAG's approach was to set out its concerns in broad alignment with the council's original reasons for refusal, and then invite the inquiry to infer from Mr. Yarwood's proof of evidence that the appeal should be dismissed. The difficulty with that approach is that Mr. Yarwood failed to deal with three matters which it was necessary for him to consider if, as he claimed, he was providing unbiased expert evidence to the inquiry in his capacity as a chartered town planner in accordance with the guidance of the RTPI. First, Mr. Yarwood failed to consider whether there were any factors weighing in favour of granting planning permission. As Mr. Yarwood accepted in cross-examination, an essential part of the exercise of providing unbiased expert planning evidence in a planning appeal is to identify any factors weighing in favour of granting planning permission, any factors weighing against the grant of planning permission, and then make a fair independent judgment on whether the planning balance comes down for or against the proposal. However, Mr. Yarwood conceded in cross-examination that his proof did not in fact contain a single statement acknowledging any of the benefits that the proposal would deliver. His proof did not even acknowledge the most obvious benefit of all, namely the provision of up to 423 dwellings in a district that has a paltry housing land supply, frankly, of only 1.36 years. With respect to Mr. Yarwood, it was not credible for him to claim that he was acting as an unbiased expert in providing evidence for WAG if his proof focused only on what he considered to be the factors weighing against the grant of planning permission and ignored all factors weighing in favour. Mr. Yarwood did not make the implausible claim that the proposal would not lead to any benefit at all. Indeed, he accepted in cross-examination, somewhat begrudgingly, that the provision of 423 dwellings towards the council's housing land supply would be a benefit. That being so, it was incumbent on Mr. Yarwood, as WAG's appointed planning expert, to make a planning judgment on the weight to be ascribed to that benefit and consider what bearing that had on the planning balance. He did not do so. This was such a fundamental omission in Mr. Yarwood's proof that it cannot, with respect, be properly regarded as an expert planning appraisal of the proposal. What WAG presented as a proof of evidence to the inquiry was, in truth, an advocate's statement that simply advanced a one-sided case against the proposal. That one-sided approach meant that WAG's proof of evidence was also silent on the weight that should be given to the other indisputable benefits of the proposal, including most notably, first, the introduction of a new sustainable drainage system to control runoff and reduce flooding that is currently caused by uncontrolled runoff from the site and surrounding catchments. Second, the provision of over 10 hectares of open space, including a countryside park, with significantly improved public access to the site. And third, the economic benefits of increased economic activity during both the construction and operational stages of the development. Second, because Mr. Yarwood failed to undertake any planning balance, he also failed necessarily to consider the statutory question of whether the proposal complies with the development plan as a whole. Mr. Yarwood suggested in cross-examination that it should be inferred from his evidence that he does not consider the proposal to comply with the development plan as a whole. But that suggestion was not open to him when he completely ignored the obvious benefit of providing 423 houses on the site in accordance with an allocation in the development plan. In any event, even if Mr. Yarwood's one-sided exercise were assessed on its own terms, he did not even undertake a global assessment of whether the harms that he alleged were sufficient by themselves to render the proposal in breach and as a whole. The exercise was seriously deficient with respect, however it is approached. Third, there is the additional consideration that the tilted planning balance in paragraph 11D of the framework is engaged in this appeal by virtue of the fact that the council only has a 1.36-year housing land supply. The appellant's case is that it doesn't need to rely on the tilted balance because the proposal complies with the development plan for the purposes of para 11C of the framework. As Mr. Yarwood did not conclude in his evidence that the proposal complies with the development plan, having, as I've noted, ignored that question, it was incumbent on him as a planning expert to grapple with the implications of that for the tilted planning balance that was thereby engaged given the council's 1.36-year housing land supply. Not only did Mr. Yarwood not carry out any form of tilted planning balance, he failed to acknowledge that the tilted balance was, on his own appraisal of the application, engaged. As a result, WAG's evidence to the inquiry is also silent on the critical question in that scenario of whether any adverse impacts of granting permission would significantly demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole, having particular regard to key policies for directing development to sustainable locations, securing well-designed places, and providing affordable homes individually or in combination. This was another serious omission in what purported to be an unbiased expert appraisal of the proposal. And so we renew our invitation to you, Madam, to conclude in accordance with the common ground of the appellant and the council that the proposal complies with the development plan as a whole and that the proposal should accordingly be approved without further delay. It's a para 11C case, we say. As Mr. Dickinson explained in evidence, that the proposal does not, on the appellant's case, breach any development plan policy, it's strictly unnecessary to ascribe weight to the various benefits of the proposal before concluding that planning permission should be granted. However, should you be assisted by Mr. Dickinson's weighting of individual benefits, Madam, they are set out in his proof and I need not repeat them. Moreover, while it's correct to say that the council's extremely low housing land supply of 1.36 years engages the tilted balance in para 11D of the framework, this is not a case in which the appellant needs to rely on the tilted balance to succeed in the appeal if its proposal engages 11C of the framework instead. Suffice to note, as Mr. Dickinson does in his proof, that insofar as you might be minded to consider the tilted balance in any event, Madam, it follows necessarily from the appellant's case, and indeed its common ground with the council, that the proposal would not have adverse impacts that would, quote, significantly and demonstrably outweigh the benefits when assessed against the policies in the framework as a whole, having regard to key policies for directing development to sustainable locations. So for all of those reasons, Madam, we respectfully invite you to allow this appeal.
Thank you, Mr. Lewis, and you can have a chance to rest your voice.
Very grateful.
So we're now at 12:55. The parties indicated last time we met that there were no costs applications being made. I just wanted to double check that situation. And if I can turn to the Wolds Action Group first of all, please.
That's correct.
Thank you, Mr. Yarwood. And the council?
Sorry, yes, that remains our position. Thank you.
Okay, thank you. And the appellant, Mr. Lewis?
Also remains the position for us, Madam, no costs application.
Okay, thank you very much. So just in terms of what is still expected in terms of this inquiry, we have previously agreed that I will be updated on the legal agreement when it reaches the county council, and if an indication can be given when it does reach the county council as to how long it might take from then on, I'll be in a position then to issue the decision once the legal agreement has reached me in a signed and completed manner. So bearing in mind that I only have the legal agreement left, I don't have any other issues that I wish to cover. I'll just ask if there's any other procedural or housekeeping matters. Wolds Action Group, first of all, please, Mr. Yarwood.
No other matters, no.
Thank you, Mr. Yarwood. And anything for the council, Mr. Cosgrove?
No, thank you, Madam.
Okay, thank you. And Mr. Lewis?
Nothing from us, Madam. Thank you.
Okay, so thank you very much for all your contributions in the inquiry over what has taken. It's been quite a long time. It seems a very long time since March, certainly. But I do appreciate all the hard work that you've all put in. Thank you very much. And with that, the inquiry is now closed. Thank you very much. And
Thank you.
Have a good afternoon.
Thank you, Madam.
Cheers.
Very grateful. Thank you.
Bye-bye.
Goodbye. Goodbye. Thank you.